Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On November 10th, the court heard arguments in City of Austin, Texas versus Reagan National Advertising, a case which concerned whether the Austin City Code's distinction between on-premise signs, which may be digitized, and off-premise signs, which may not, is a facially unconstitutional content-based regulation under Reed versus Town of Gilbert. With the decision likely to be rendered in the coming weeks and months, I am joined today by Trevor Burrus, Research Fellow at the Cato Institute's Robert A. Levy Center for Constitutional Studies. Trevor, we're grateful to have you. Welcome.
Thanks for having me.
So before we get to oral argument, could you please walk listeners through a bit of background, as we can note from the question that the court is going to be grappling squarely with earlier precedent?
Yeah, it's sort of an interesting case because in some people might think it's a pretty navel-gazing First Amendment case. So it's about billboards and digitization of billboards and the meaning of content-based. The company that brought this, of course, Reagan National Advertising, they wanted to digitize billboards that were off premises, meaning that the billboards were advertising something that was not at the location of the billboard. In other words, this is a common distinction in many municipality sign codes, which are always justified based off of aesthetics and usually distracted driving too. But they say, if you have a barbecue business, you can put like "come here for barbecue," and that sign can be digitized if it's on the premises of the barbecue business. Let's say Franklin Barbecue in Austin, which actually came up in oral arguments. But if you are off premises and you're advertising something like "go to Franklin's Barbecue," but it's a sign that is off premises, you couldn't digitize that. And so Reagan National had a bunch of billboards that were off-premise billboards, meaning the kind of ones on the side of the road. And they wanted to digitize them because obviously that's what you'd want to do if you ran a billboard company, because otherwise you'd have to go in and have the physical labor to change the billboard. So it's just much more effective to have digitized billboards. And the city of Austin said no. So, it could probably cost them a lot of money, which is one reason they went to the Supreme Court. The other backstory of this is a case called Reed versus Town of Gilbert, which came out in 2015. And if any of you have ever been to law school, there's the First Amendment is not exactly clear, but one of the really important things that you have to kind of wrestle with is what's the difference between a content-based restriction and a non-content-based restriction. A content-based restriction, historically speaking, has to look at the content of the speech in some way. The other types of restrictions that wouldn't be content based, there are restrictions on speech that would not be content based. For example, the amount of volume you could put onto a loudspeaker, driving around a truck or at some sort of rally. That's not a content-based restriction, but it is a restriction on speech to some degree, or how late the rally can go. It's still a restriction on speech, but it's not a content-based restriction. And historically speaking, the Supreme Court has looked very skeptically at content-based restrictions, partially because of the whole meaning of the First Amendment. So if you really think about it, the First Amendment is one of the many parts of our Constitution that expresses just general skepticism towards government agents doing something for good reasons. The First Amendment says we kind of suspect that if they're banning speech, the government is doing it for bad reasons. So we kind of suspect that if some local sheriff finds out that there's a bunch of pamphlets being passed out in a park attacking him, and so he bans pamphleteering in the park, or he enforces some sort of ban, we kind of suspect that he's doing this for self-serving motives. And so it's important that we get it correct in terms of what sort of things we're going to put strict scrutiny to. And strict scrutiny is, of course, this is part of the suspicion. We put strict scrutiny often on things where we suspect that the real motivation or effect of a government policy could be pernicious. So the same is true for racial classifications, for example. And so if we do strict scrutiny, it means we're going to look very closely closely to make sure the government is not just trying to suppress speech. And it's much more likely that they're doing that when it's a content-based restriction. And so it's the issue in this case is what is the definition of a content-based restriction? And then does it apply to the Austin Code in this case? And in Reed, the court sort of did away with a bunch of somewhat confusing precedents about the definition of a content-based restriction and said if on the face of the law you have to look at the content of the communication to know how to apply the law, then it is a content-based restriction. If you don't have to do that, as in the case of the volume restrictions or something like that, it's not a content-based restriction. And so in this case, the argument is the argument from, well, in this case, first of all, the city of Austin lost at the Fifth Circuit because the Fifth Circuit applied Reed and said, yep, this is a content based restriction. Why? It's a content based restriction because in order to figure out if it's advertising something on premises, you have to read the sign. And that might sound a little inane, possibly, or simplistic, but there was a lot of virtue in the Reed decision, and a lot of people championed it, including myself, because good, easy to apply rules are often what you want in constitutional law, and Reed is pretty easy to apply. There are also a lot of pearl clutchers who said this is now such a really, stark rule. Just if you have to read the content of the communication or listen to the content of the communication to apply the rule, then strict scrutiny applies. And a lot of people said this is going to apply strict scrutiny to a ton of stuff, and a bunch of sensible speech regulations are going to get struck down. Now, remember, in this case, the first question is what kind of scrutiny do you apply? And then the next thing is you apply the scrutiny and ask whether or not it passes that scrutiny. And so in response, and so this Reagan National Advertising, that was petitioners for the city of Austin, they just said this is very clear. It is a easy application of Reed, and then the sign ordinance fails strict scrutiny because they allow a ton of digitized signs all over for on-premises things, and there's no narrow tailoring that is applied to justify that not digitizing off-premises advertising. And on the other side, for the city of Austin, we're arguing for intermediate scrutiny, but kind of doing it in a weird way. They tried to narrow Reed in a way that I think was misreading the opinion, but they also spent a lot more time talking about the sensibility of the regulation. And Canon Shanmugam, who expertly argued the case as he does a couple times a year, kept pointing out to the court that what was really going on here was that they were trying to skip the first question and make Reed narrower and say, no, this is intermediate scrutiny because it has nothing really to do with the purposes of the First Amendment. This is about signs and highway beauty and all these things. It's not about political speech or censorship of books or something like that. But that's not what Reed says. The First Amendment, you have a very clear rule in Reed. Sort of the first question is what level of scrutiny applies, and the next question is does it pass that scrutiny? The thing is, a lot of the people who said some of these signs wouldn't be able to pass the scrutiny of some sort, I think a lot of them might. Some of the hypotheticals that were asked in the oral argument. But the first question is what Cannon kept going back to: what level of scrutiny applies? And the Reed rule is very easy to apply. The argument itself, I would say, if I were a betting man, because so many justices on this court were voting in the Reed case, I would say that the Reagan National is going to persevere in this case. But it would be interesting to see if they try to do anything to narrow Reed whatsoever, because it's possible that many of the justices and many of them in oral arguments seem to think that they were afraid of how sort of harsh Reed is, like some of the commentators at the time of the decision came out, that it's so harsh that all of these municipalities had to, redo their codes for signs that have been around for decades and decades and decades to avoid the harsh rule in Reed. But it's a good rule, I think, because it's important to have a very good and easy to apply definition of content based, and then you apply strict scrutiny, and in so doing you can suss out sort of government malfeasance and bad regulations of speech. I wasn't terribly surprised by any of the justices in the argument. This case very much is about this sort of eternal legal question of clarity versus nuance to some extent, and whether or not a rule, like there's a lot of questions that were like kind of saying, well, it's formally true you have to read the content to do this, but like, is it really what the First Amendment is concerned with? That there are a lot of questions along that line. That this is not about First Amendment values. This is about whether or not we're going to apply a maybe formalistic harsh test from Reed just in every instance and start hitting various relatively innocuous speech regulations. Even I would admit that. My passion for the First Amendment is not based in my passion for digital signs, but like that, this harsh rule was so harsh that you were to go around just knock down these innocuous speech regulations all around the country. And so there's a lot of questions like that, but there are also a lot of questions where they were trying to figure out how this would apply. And it's a good example, actually. I think at the end of the oral argument, Justice Gorsuch gave some examples and asked Cannon to guess how the city of Austin would apply the ordinance. So, and this is one reason I think in that little sort of interchange between Gorsuch and Cannon that you showed why content based is important to have a good definition, and why it's important to keep strict scrutiny on content based, because government agents could use it poorly and use it in their own interests. And so in asking that, he said, would a Black Lives Matter sign be on premises? And he said, well, it's not commercial speech, so probably not. He said, well, would a Black Lives Matter sign announcing a rally be advertising something off premises? All right. So if a business put up a Black Lives Matter and said there's going to be a rally, would that be advertising something off premises? And Candace said, you might have to ask, the city of Austin this, of whether they consider that commercial or an event. He's like, well, what if it has the date and time of the rally? He's like, well, that's probably getting close to the type of sign that is prohibited. And there you see, this is not just about advertising Franklin's barbecue or Salt Lick barbecue, which came up a couple times in oral argument. It's also about substantive, the city of Austin applies this to non-commercial speech too, which is one reason why this is not a commercial speech case. And so in those situations, in Justice Gorsuch's hypotheticals, you saw that this rule in this case is sort of, seemingly, harmless as it is, could really matter in terms of preserving First Amendment values.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.